Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-5065. William Skewes-Cox, appellant, versus Georgetown University Law Center and Department of Education, Office for Civil Rights. Mr. Skewes-Cox for the appellant, Ms. Schuster for the appellees.
Good morning, whenever you're ready.
Good morning, Your Honors, and may it please the court. The district court's findings that service is defective and that in the alternative I failed to state a claim are erroneous. Regarding service of process, the district court's findings rely almost entirely on the fact that I filled out the return address field on the envelope that contained the summons and the complaint. The district court relied on this fact to find that I had personally mailed the summons and the complaint. This is despite the fact that I submitted to the court a signed affidavit signed under the penalty of perjury from a third party stating that she had in fact mailed the summons and the complaint.
Putting aside the facts of this case, are you willing to accept the general proposition that a plaintiff can't self-serve?
No, Your Honor. The district court relied on the Johnson-Richardson cases for the proposition that a plaintiff may not mail the summons and complaint by himself or herself. The plain text of Federal Rules of Civil Procedure Rule 4 says that service of process can be effected under the local rules, and the local rules in this area are the rules of the DC Superior Court, which permit a plaintiff to mail a summons and a complaint himself.
Which is one option for manner of service under 4E, which seems independent of the who should serve rule, which is 4C.
Correct, Your Honor. And there are, while Georgetown has pointed to Johnson-Richardson for the prohibition on a plaintiff mailing a summons and a complaint, there are other cases at the DC District Court level where a plaintiff has mailed a summons and complaint, and that service has been recognized as properly served without much analysis or further explanation, because the plain text is clear under Rule 4E, and it's uncontroversial in DC Superior Court that a plaintiff may do so. Because the district court's finding of ineffective service entirely relies on, one, the fact that I filled out the return address field, which in my opinion is completely irrelevant to whether I mailed it or not, which I didn't because there was a third party who submitted a signed affidavit under the penalty of perjury that she did. There's no other finding to support the district court's conclusion that service was not effective. Georgetown alleges that service was not effective because it was not received by an authorized agent or there was not a return receipt. The district court made no findings on either of these arguments raised by Georgetown. Georgetown raised them before the district court twice, and 2 times the district court said nothing on these 2 other arguments.
Certainly right.
We can affirm on any ground.
Correct.
So why, suppose we agree with you on your principal point that second time around you had your friend do the service. So you win on that ground. Why shouldn't we affirm on the alternative ground that there was no receipt?
First, the district court made no factual findings, whether there was or was not. So as a court of review, my opinion is that there's nothing in the record. There aren't sufficient facts in the record for this court to make that finding. In the alternative that this court does agree with Georgetown.
It's your burden to prove service.
Correct. And there are attachments that I submitted to the district court that I believe meet my burden on these two other requirements that Georgetown has raised. The district court did not make any findings on that. Even if
What in the record would show that there was receipt and return?
So there is the attached to the service of process affidavit, there is the green certified mail receipt there, filled out in the handwriting of the third party who.
No, I know, I'm giving you that.
Okay.
Focused on the receipt
and
point.
also the tracking and everything. I also submitted a screenshot showing it had been delivered. And it's addressed to the Office of the General Counsel. Georgetown claims that their general counsel is not authorized to accept service of process. Even if this court agrees with Georgetown that for those alternative reasons, service was defective, I should be given a further opportunity to effect service. One, because even though Georgetown had raised these arguments twice, the district court never relied on these. And if we are going to look to Johnson-Richardson, the pro se plaintiff in Johnson-Richardson was given 3 chances to effect service. Also in Johnson.
You sort of had a third chance. The district court dismissed the second time and the limitations period was still open. You could have reserved.
So the district court dismissed, in its last order, dismissed it without prejudice, but did not give, unlike its prior order, did not give me another opportunity to further effect service. And in Johnson-Richardson,
the dismissal is without prejudice. Why wouldn't you have that just from the without prejudice?
I suppose I could have refiled and started the whole process again, but I also immediately took leave of appeal, and well, now we're here. And again, in Johnson-Richardson, that court found after 2 attempts of service of process based on the mailings issue that has been at issue in this case, that plaintiff had not mailed it to an agent authorized to receive service. And that plaintiff was given another opportunity to effect service. So if we're going to rely on Johnson and Richardson, which again, my position is that the several other cases that, uncontroversially accept that a plaintiff can serve through the mail is my preference. But if we're going to rely on Johnson Richardson, then as a similarly situated plaintiff, I should also be given a third opportunity on remand to effect service. And I can affirm and swear to this court that I will hire a professional process server so we won't be in this same territory again.
No, well, I have a question about standing. Georgetown argues you don't have standing, and I just want to make sure I understand your theory of it. Is it essentially that this grade is going to harm your future job prospects, and that's the injury that you're trying to remedy?
Correct, Your Honor. The harm is this illegitimate grade on my transcript. And every time that I apply for a job, I'm asked to declare my GPA, and they ask for a copy of my transcript. So this is an ongoing violation. There's continuing harm. Unfortunately, as lawyers, our law school GPAs do end up determining a large part of our professional opportunities.
This may not end up being important, but we don't know which direction. I can assume which direction you think your GPA would change if this was changed to a pass, but we don't know from the papers, and we don't know how much. Do you know how much your GPA would change?
Okay, I don't want to get in trouble by offering facts to the court that are not already contained in the record, but yes, I've recalculated my GPA, and it would have been the difference between graduating cum laude and not, which is very significant. For example, federal clerkships many times have as a requirement that an applicant must have graduated at least with cum laude. And so any time that I look at any sort of job posting, I'm left out of an entire category of opportunities due to this illegitimate grade on my transcript that ended up being outcome determinative for whether I received honors or not. As regards the district court's finding that I failed to state a claim, first, the district court improperly construed the facts in a light actually most favorable to the defendant and not the
Running into your red light. I'll give you a minute.
Okay, thank you, Your Honor.
Do that.
First of all, I would state that it demonstrates an inherent bias that affects the entire legal reasoning. The district court said that I turned in a subpar paper and received a poor grade. That's not even something that Georgetown has stated in any of their filings. It's something that the district court completely made up. And it's an adverse, one, it violates construing the facts the light most reasonable to me. But it's evidence of judicial bias in that this order is based on facts that they completely made up. And again, my view of my legal claim is that I was otherwise discriminated against because I raised an issue about whether professors fulfilled their minimum requirements under the rules of Georgetown. And in deciding that issue, which was unrelated to my modest extension in a paper, Georgetown decided to excuse their professor's failure to meet their minimum requirements.
Thank you. We'll give you some rebuttal.
Thank you.
Ms. Schuster, good morning.
Good morning, Your Honors. May it please the court. I'm Stephanie Schuster here on behalf of Georgetown. I want to pick up where plaintiff left off on the notion of judicial bias. I think the record shows the district court
Let's
treated
start on this.
Yeah, plaintiff fairly and reasonably. The lawsuit is properly dismissed because it was procedurally and substantively defective in at least 3 ways, starting with service, Judge Katsas. Plaintiff failed to properly serve Georgetown despite getting a second opportunity to do so. Both times he attempted service himself, contrary to both the federal rules and DC law. And both times plaintiff failed to direct the papers to a person authorized to accept service on Georgetown's behalf and consequently failed to produce proof.
On the first point, your first ground of insufficient service, why isn't it enough for him to hand it to a friend who put it in the mail? I mean, this rule that you can't self-serve by mail is ridiculous enough to begin with. And he has a friend do it, so.
Certainly, Your Honor. If he'd had a friend, if the district court had found that his friend had actually deposited the envelope in the mail, that would be effective service in our
An
view.
affidavit.
Yeah, but
friend submitted the affidavit.
The affidavit is very clear. The person who signed it.
The only question is whether the friend putting the papers in the mail is rendered invalid because he wrote out the address and the return address.
I disagree with that, Your Honor. I think that's inconsistent with the district court's findings. What the district court found is that it wasn't clear from the face of the affidavit. And if you look at the affidavit, the person who signed it does not attest that she served it. She did not say, I delivered these papers. There are several boxes to check where a process server can check, I served, I left, I returned the summons. That wasn't done here.
Counsel, I'm just reading from footnote in the district court opinion. He had a third party deliver his complaint and summons to the U.S. Postal Service. I don't see it at any time when he says the affidavit is unclear.
I'll point you to it, Your Honor, if you bear with me for just 1 second. He says the affidavit, the attachments to the proof of service are not exactly clear as to who submitted the package. Bottom of page, it's on 97 of the appendix, page 5 of the opinion. The exhibits attached to his proof of service do not clearly indicate who physically submitted the package complaint to the U.S. Postal Service for delivery. And if you look at the affidavit of service, it says, where she checked other, she says, in the passive voice, sent by certified mail. The district court had that, and it had the evidence of the envelope, which says from the plaintiff. Plaintiff had an opportunity to submit additional evidence. He didn't. But based on the evidence in the record, the district court's conclusion that plaintiff served is not clearly erroneous. And its decision to dismiss rather than give plaintiff a third chance at the apple, a third bite at the apple, was not an abuse of discretion. But even putting aside who sent the papers, we have the other deficiency that the papers were not directed to an appropriate person authorized to accept service. Again, the federal rules and DC law require entities to be served via a registered agent or a person authorized to accept
Who's
service.
the appropriate person?
The registered agent, I believe, is
The general counsel?
CT Corp. The general counsel is, I mean, at Georgetown University's general counsel is a vice president, and
Is-
so could
Is
be,
the law school separately incorporated?
I believe it is, but but
And the law school has its own?
the law school does not have its own general counsel. The Georgetown University's Office of General Counsel is the Office of General
Seem to be
Counsel.
the right person.
It could be if it was delivered to them, but the Office of the General Counsel, from a simple Google
So is
search,
it-
is not located at the law school.
It-
There is no Georgetown
fact
Law
is-
General Counsel.
Problem was it went to New Jersey Ave rather than across the river in Georgetown.
Correct. It was not directed to the appropriate office or to the appropriate person. And that's why there's no return receipt showing it was received by the Office of the General Counsel. Effective service is essential to personal jurisdiction, and for good reason. If you look at what happened in this case, the first misdirected service, not directed to an authorized person, resulted in entry of default against Georgetown. That's when Georgetown learned about this lawsuit. These aren't mere technicalities. These are essential requirements to personal jurisdiction. And as this court has made clear, courts have uniformly held that any judgment rendered in a case where service does not comply with the effective service requirements is invalid.
I'm sorry, who did you say he should have served?
He could have served the Office of the General Counsel at its address, because that individual whose name is not placed in these papers is an officer of Georgetown University. Under the rules, an officer of an entity or another person legally authorized to accept service, like a registered agent, would have been appropriate. Georgetown also has a registered agent. But even putting the service issues aside and turning quickly to standing, plaintiff lacks standing because he seeks only declaratory and injunctive relief, both of which are forms of relief that require either an ongoing injury or an imminent future injury. Plaintiff has asserted in his reply brief and then here again today that his grade being permanent on his transcript might harm unspecified job prospects. The complaint doesn't support that theory. It's not alleged.
I mean, why wouldn't Mr. Skewes-Cox have standing to have his grade petition reviewed without animus?
Well,
I mean, it's a kind of procedural harm, arguably, under the Rehabilitation Act.
certainly, but he does not have the sort of injury in fact necessary to have the grade petition reviewed. He does not have an ongoing injury that supports
Why
giving the
is
court
that?
jurisdiction. Because he does not,
He needs, it's a little bit abstract, but we look to harms analogous to common law, I mean, defamation, FICRA cases, if you have adverse information in your credit report, maybe it harms you going forward with some future application, maybe it doesn't, but that is not too abstract an injury for Article 3 purposes.
I do think it's too abstract an injury for Article 3 purposes. It's not concrete. He's not alleged. It's pure speculation based on the assertions, which again are unalleged, not in the complaint, but based on the assertions in his briefing here today.
Man, I'm
He
just,
speculated about it. The Article 3 requires plausible allegations at this stage of a concrete, particularized, and either actual or imminent injury.
I didn't go back and reread Spokio, so I'm doing this from memory, but like there was a distinction between information like the person has the wrong zip code versus information that, the person is a tax cheat or something. And that's bad grade seems more like the latter.
Right, a concrete injury needs to have a real world, we're talking about concreteness at this point rather than whether it's ongoing. It was what Spokio was about. But in terms of it being concrete, it need to have a real world impact. You need to allege some real world effect that actually resulted in negative
We're
impact
all
on it.
lawyers. We all know that law school GPAs matter for job prospects.
Certainly, GPAs matter for all sorts of job prospects, Your Honor, but the plaintiff has not alleged a single instance where he attempted to get a job and was
But
denied
does
or
he
were his
have to allege that in order to show that he has standing for what's a sort of procedural harm to have his grade reviewed without animus?
He does. He needs to allege an ongoing harm that affects him in a real way for the court
Well, the
to
harm
order
is
that
that
relief.
his allegation is that his grade was reviewed, with bias. And so if it were reviewed without bias, the outcome may be different. And in that kind of procedural harm, ordinarily causation and redressability is somewhat relaxed. He doesn't have to show that his grade would definitely change or that it would change, in a certain direction.
And the definiteness of the change is not our argument, but he does need to show that the injury is ongoing. A past injury is not enough to make out a present case or controversy for a plaintiff seeking the type of injunctive or declaratory relief that he's seeking. But moving to the point of animus, I see my time's about to expire. So let me turn to the final grounds. Putting aside lack of personal jurisdiction, defective service, lack of standing, the plaintiff also fails to state a claim. Whether it's construed as a failure to accommodate claim or a disparate treatment claim based on animus, plaintiff doesn't plausibly allege that his grade change was denied because of or by reason of his disability. He never requested that Georgetown extend the deadline for him to submit his final paper, even though he sought and was granted an extension of the interim deadline to submit the draft for feedback. Plaintiff challenged his grade because, as a result, he had less time for feedback. The complaint doesn't plausibly allege that Georgetown denied that challenge because of the fact that he requested an accommodation. The complaint makes clear Georgetown denied the allegation because plaintiff chose this truncated review period and then complained about it after the fact. Plaintiff's choice to seek that extension defeats this disparate treatment claim or an animus claim in two ways. One, it breaks the causal chain necessary to make out that claim. But another, it demonstrates that on the face of the complaint, there is an obvious alternative explanation to any insinuation of animus that is now being argued on appeal, that this was plaintiff's choice. He asked for this. He did not. He had options available to him and did not exercise them. I see my time is about to expire. So unless the court has questions, for these reasons, we'd ask that the judgment be affirmed. Thank you.
Thank you very much. Mr. Skewes-Cox, we'll give you 2 minutes.
Okay. Thank you. On rebuttal, I would like to draw the court's attention to the proof of service affidavit found on page 35 of the joint appendix. To parse the language, Georgetown has said that, again, I delivered it the second time. We have this affidavit signed under a penalty of perjury, and just reading through the text here, it says, this summons for Georgetown University Law Center was received by me, referring to the third party, on April 6, 2023. And then she checks the box and says, sent by certified mail. If we look at the yes, okay, I is not there. But if we look at the context of this, it's saying received by me and sent on by certified mail, blah, blah, blah. So the context here is clear that it was she. There's a missing I here, but the context is clear that it was her who sent it. And again, I mean, if Georgetown's position here is that service was defective now because there was an pronoun I missing after the pronoun me, I mean, I think that stretches all reasonability. And given the fact that, again, I'm a pro se plaintiff here, working with a third party to effect service, I mean, it's just unreasonable. And in the grammatical context here is clear that it was sent by her. To conclude, even if this court agrees with Georgetown that for one of these reasons, services, even if the court agrees that, for example, plaintiffs are prohibited from filling out a return address field, and that should trump an affidavit signed under the penalty of perjury, I should get another opportunity to effect service, even if the court agrees that I lack standing or that there was a failure to state a claim. Again, I would ask that this court grant me leave on remand to amend the complaint to comply with these standards as is custom under Rule 15.
Thank you, counsel.
Thank you.
The case is submitted.
Case number 24-7077. Eugene Hudson Jr., appellant versus American Federation of Government Employees, AFGE. Mr. Bone for the appellant, Ms. Oppenheimer for the appellee.
Mr. Braun, good morning.
Good morning, Your Honors. May it please the court, Harold Bone II for appellee. Appellant, apologize, Eugene Hudson Jr. So this case raises three issues on appeal. First, that the jury instructions may or may not have followed 101A2. Second, that a jury may review the instructions or the actions of a union pursuant to the union constitution for reasonableness. And third, whether or not a violation of a 101A2 is required to have a remedy on appeal. So due to the complexity of the three issues, the relative complexity of the three, I intend to devote the time solely to the first part or a aspect of the first issue, namely,
Instructions, right? The jury instruction.
yes, namely the test for infringement. So
I'm sorry.
the test for,
I didn't hear you, sorry.
yes, I intend to talk about only the test for infringement. So when a statute or when a word is not defined in a statute, it takes on the common law aspects of it. That is especially true here where the Supreme Court has stated that labor management statutes have a common law aspect. And the legislative history shows that Congress intended for common law judgment to be applied to the statute because of the myriad ways that union democracy can be formed by its members. So when we say that a right shall not be infringed, we don't look to the mental aspect of the tortfeasor. We look at the burden of exercise on the right holder. So under 101A2 specifically,
The claims you pursued were for retaliation, correct?
retaliation was a theory that was presented in the,
And wouldn't that necessarily turn on the reason for the decision?
in a sense, yes, but as mentioned in both the jury instructions before trial, the new trial motion, and on appeal, it does not require but-for causation. Specifically, it was mentioned in Comcast.
But it does require
A causal
an
link.
impermissible motive. Before we get to causation, just they have to have acted for they have to have a bad reason,
So motive may be involved,
right?
but that is different than motive causation. Motive causation requires one to prove the mental state of the tortfeasor. With a reasonable person test, you only have to prove the perception is that of one who intends to commit a tort. There's a big difference. So, for example, a person emerging from a forest with a bloody machete may or may not be the gentlest person in the world. However, that does not mean that one may not feel reasonable fear based on what they're perceiving. It's the same thing here. So in association, yes.
Take your time.
In the Supreme Court case of Lynn, we saw that the Supreme Court stated that it was sufficient for Lynn to show that the trustee stated that he acted with the intent to remove him because he spoke out against the fee increases. However, sufficiency and necessity are two different things. And the Supreme Court went further to say that that objective evidence of the trustee stating that he was acting on the speech was sufficient to show that it was reasonable for the union members who observed that speech act to feel a chill underneath all of that. And that is the precise thing that 101A2 is targeting. So the free flow of communication between union members is the union's immune system against autocracy. When that free flow is interrupted, there is the threat that autocracy may set in, and that is when judicial intervention becomes necessary.
Mr. Bone, can we talk about, you said that the common law standards should govern how we understand this. But for causation, isn't the usual common law standard but for causation?
For motive causation, if you're applying a reasonable person standard, the causal link is not between the speech act and that of the union officer. It's between the union officer and the observation by the union members. Is the chill that is attempted to be prevented by 101A2. And as was stated in Meacham, because the rule that is asserted here is part of the affirmative defense, it can also be part of that but for that is used for the standard inside of itself. It can be both sides. So since the text is already stated that is in the affirmative defense, it can be part of the but for. So Bastanti was mentioned as well in both the reply brief and the main brief. And we saw there that there was causation mentioned as well. But Bastanti was affirming the district court there. And if you look in the slip opinion on page 12, you see that the district court there uses an any motive standard, which is conformable to the causation method. So there you see that so there's a bit of a shifting there. And we saw in the appendix on page 236 where it was asserted that there was an error in the motivating factor test. Motivating factor was asserted.
In Bastani, we said that the action has to be causally linked to protected speech. But did this court otherwise specify what the causation standard should be? I don't think Bastani says what the causation standard should be, or do you read the case differently?
The circuit court does not say what the causation standard must be, but the district court that it was affirming used an any motive standard both at summary judgment and at trial. So it was seen that the any motive standard should carry the day again here, especially in light of Comcast, which says that the text, the structure, the history, and the purpose of.
Can I ask one clarifying question? So I understand the argument you're focusing on today is essentially that causation is objective. Would
Yes.
this conduct chill an objective union member? Below, Mr. Hudson also argued that the test should be motivating factor instead of but for causation. Are you making that argument on appeal, the motivating factor argument, or are you abandoning that?
No. So again, the error that was asserted was that the but for motive causation test was incorrect. The motivating factor test is offered as an alternative in case the court does not agree with the objective standard.
Okay.
So again, we saw also in the purpose of the statute that Congress intended for the union officers to be held to the highest ethical standards. That also supports the any factor, any motive test. And we also saw in the legislative history that when they were approving the final amendment, Senator Kutchel stated that they intended for the rule of reason to apply. That would also support the reasonable member standard. Since the chill is the focus of the test, as stated in Reed, as stated in Hall v. Cole, it would follow that the reasonable member test is the one that should be applied at the outset before the affirmative defense is applied. So, and again, there's this issue about measuring motive as well. If you have a retaliatory motive but for standard, and you have a committee, say of 5 people, if two of those people are acting in retaliation for the speech, if one of them is acting using the speech as, say, a pretext simply because they dislike the individual, and two of them are applying just a stated rule or a bylaw, it is somewhat unclear whether or not that is a but-for for the purposes of any motive causation test, because that third individual, they're not acting in retaliation on the speech. They're just acting in general disgust or dislike. And as we saw with the causal chain throughout.
I'll let you
Of
finish
course.
your thought.
Oh, sorry, I apologize. I see my time is there. Thank you, Your Honors.
Okay. Ms. Oppenheimer. Good morning.
Good morning, and may it please the court, I'm Elizabeth Oppenheimer for the Appellee American Federation of Government Employees. None of the arguments that Hudson is raising before this court was timely raised before the district court. And in particular, the reasonable person standard that Mr. Hudson's counsel just spoke about bears no relation to the retaliation claim that was tried before the district court.
On the jury instruction, do you think this is a plain error case or an invited error case?
I think it's an invited error case. I don't think he prevails either way, but the jury instruction did not state any coherent causation standard. It didn't state a coherent motivating factor standard. It didn't seem to state a but-for standard.
Feels a little bit like invited error to the extent he's challenging his own proffered instruction.
Right. We did cite a recent case from this court in our brief saying that a party cannot challenge an instruction that they gave. It may be that part of his instruction now matches part of his theory, but his instruction taken as a whole, if he's challenging the instruction taken as a whole, then I agree with Your Honor that it's an invited error. As you've just referred to, all of the claims are under either a plain error or more demanding standard of review. We set forth in our briefs why none of the claims meet that standard, and I don't want to repeat our briefs, but I'm happy to answer any questions Your Honors may have.
Garcia? Happy to rest on the brief?
Happy to rest on the brief. Thank you, Your Honor.
Mr. Brown, we'll give you 2 minutes.
So again, I would just say that we weren't challenging the entirety of the jury instructions, just the parts that were isolated for the causation standard. And that was mentioned as well in the briefs. So unless Your Honors have any further questions.
Judge Garcia, Judge Rao.
Thank you.
Thank you. Case is submitted.
The honorable court now stands adjourned until Friday, March 7th at 9:30 a.m.